5 seconds to go. Start. The learned counsel appearing for the state supported the impugned judgments. He submitted that the prosecutrix evidence cannot be discarded on technical grounds when, in substance, the prosecutrix has established that there was forcible sexual intercourse. He further submitted that the law is settled that the prosecutrix may not sustain any injuries and therefore her version cannot be disbelieved on the ground that she did not suffer any injury. He lastly submitted that there is no scope to interfere with the concurrent findings of fact. The learned counsel appearing for the prosecutrix relied upon the WhatsApp conversation between the prosecutrix and the appellant accused. He submitted that though the certificate under Section 65B of the Indian Evidence Act 1872, for short, the Evidence Act, was not produced about the WhatsApp conversation produced on record, as the appellant accused had not objected to the production of the WhatsApp conversation in view of Section 294 of the Code of Criminal Procedure 1973, in short, the CRPC. The WhatsApp conversation is admissible in evidence. He relied upon the presumption under Section 114A of the Indian Evidence Act 1872, for short, the Evidence Act. He submitted that it would have to be presumed that the sexual intercourse was without the consent of the prosecutrix. He submitted that in this case the offence is under clause F of subsection 2 of section 376 of the IPC. He further submitted that as far as the prosecutrix is concerned, the appellant accused was in a position of trust and therefore clause F of subsection 2 of section 376 of the IPC will apply, and consequently the presumption under section 114A of the Evidence Act ought to be invoked in this case. He also submitted that the appellant accused had not adduced any evidence to prove his innocence. He submitted that no interference is called for, considering the concurrent findings recorded by the trial court and the High Court. To appreciate the submissions made across the bar, we are reproducing the material part of the examination in chief of the prosecutrix, which reads thus: stated, and they were and he usually visited our house. I, along with my family members, attended the marriage of accused Pankaj at village Prem Nagar in the year 2012. Accused, along with his wife, came in our house in the month of April 2018, and then I gave my mobile number to him for sending his marriage photographs on my mobile in presence of my family members. After 3-4 days, accused sent his marriage photographs on my mobile phone. Today, I do not remember my mobile number. Thereafter, accused sent good morning, good evening, and others messages on WhatsApp, and I replied the same to him. Accused making my ear against my in-laws' family, and he said that this not enough, but it is only 10%, but he will tell everything when we met. Accused Pankaj suggested one doctor to Hansi regarding my back pain. Stop.